Perfect. So, hello all. Thank you, Nathan, for inviting me. I'm very happy to be virtually with you today. And thank you also for all the people that are here today with us and participating in this presentation. So, my name is Christos Kaloniatis. I am a professor at the Department of Cultural Technology and Communication in the University of the Aegean. The University of the Aegean is a university spread in 6 Greek islands. Our main premises are on the island called Lesbos, which is in the northeast of Greece in the Aegean Sea. And actually, the concept of the university is that we spread departments and schools in 6 different islands all over the Aegean Sea. I'm also, in the last 3 years, I'm also a member of the board of the Hellenic Data Protection Authority, mainly focusing on the application and enforcement and compliance of the General Data Protection Regulation in the public and private sector. So, and also as an academic, I'm coming from the world of security, but early, my late PhD years, I turned into the privacy part, which I enjoy the most, because I like this interrelation that brings between the technical and the non-technical aspects that we need to keep in mind. And I think it's very close to what also Nathan and his research team is doing in Plymouth. So we try to see also the human elements, the social aspects, and other interesting aspects related to the technical parts of security. So privacy is a multidisciplinary concept. This is why I enjoy it the most. And today, I considered talking about a topic that is also present in the General Data Protection Regulation. So it's a demand, let's say, from the General Data Protection Regulation for all of us that we are designing and developing systems that have applicability in the EU. And it's something that is called privacy by design principle. But the privacy by design principle was here in the research area, in the research community, way before the GDPR even comes. So I remember myself in 2005 and 6 as a PhD student writing documents about this concept of privacy by design and studying about privacy by design. And today we're going to discuss a bit about this topic. And more specifically, for the next minutes, I will try to address briefly these 4 topics. First of all, since we are in a broad audience, I would like to clarify a bit some topics related to data protection and what actually, from the regulatory perspective and from the directives perspective, what data protection is actually talking about, how is applied, which are the basic concepts. So let's build some background knowledge a bit of when we're talking about data protection, what do we actually mean? And what is the concept that we try to protect? Because all these directives and all these legal documents for us, for people that are coming from an IT background, are valuable inputs that we need to align with, we need to comply with. And I think that the most important part here, before we start programming and designing systems, is actually understand the concept behind every type of legislation, behind every directive. And if we understand the concept that we understand to read behind the words, I think that it is very, very difficult to miss anything related to compliance or following up the actual letter of the directive or the law. And believe me, the background, the concept behind any type of legislation related to data protection, even if it's in EU or non-EU places, if you see all the directives in all over the world, they share the same concept. So if we understand and manage to capture that concept, I think it's much easier to manage to bring that to the products that we develop. So the first part is about the data protection terminology, few stuff about that. Then the data protection principles and the legal basis, which is very, very, very important concept when we decide what to implement. It is very important to have this legal basis in our minds. Then we're going to discuss a bit about the privacy by design aspect. So why it is important, why I picked this up out of the various elements that are related to privacy, why we consider it very, very important. And I have one slide at the end, which also is a requirement that we usually miss, at least when I discuss with my students and I bring this topic under discussion. What about data retention? We see you can hear different answers there. So I have one slide at the end of the presentation just to point out something related to personal data retention. So not backwards, forwards. So let's start with the data protection terminology. And I will follow the GDPR, let's say, vocabulary, because it's also an official directive of the EU. And regardless if you are your company is in US or Australia or China or wherever place it is, if you are planning to design and implement a product, a service that is going to be applied in EU, in the EU region, then you need to comply with these requirements. You need to comply with the General Data Protection Regulation. So it is very important, I think, to understand what is the basic requirements and actually what is the terminology behind these requirements. So there are 4 topics here. The key GDPR definitions about the personal data, the data subject, the special categories of data. What do we mean when we say processing of personal data? What is a data controller and a joint controllership, which is also very hard to, from my experience as a member of the board of the Hellenic Data Protection Authority, we see a lot of miscases there about the joint controllerships. What is the difference between a data controller and a processor? What we call recipients or third parties, and what are the supervisory authorities? And then we're going to discuss a bit about the data protection principles, the legal basis, and I'm not going to go through the data subject rights, just a list of the things that when we're talking about the people that are going to use our system, which are the rights that they have on our system. So all these are translated into actual requirements that we need to fulfill. So think about it. While the presentation is a more theoretical, has a more background knowledge, try to think as IT professionals how these notions, how these concepts should and could be translated, transformed into technical requirements. And this is why privacy by design principle is very, very, very important. So actually, what is the data protection? The data protection is the fair and proper use of information about people. So if we don't have personal data, if we don't have data related to people, then we're not talking about data protection. We're not talking about data protection in terms of privacy. Okay, so it is a part of the fundamental right to privacy, but on a more practical level. Why we want to discuss about privacy and data protection? The actual goal of having these directives, the actual goal of talking about privacy enhancing technologies, the actual goal of talking about data protection, impact assessment, and all these tools is just to fulfill one purpose. We want to enforce, we want to have this robust methodology, we want to have this concrete, let's say, approach to prove to our people, to prove to our users that they can trust our system. So we provide these safeguards, these mechanisms that we can ensure to our users that our system is trustworthy. So at the end of the day, we want to create this trust, to make users trust our system. And in order to make users trust our system, related to the part about privacy, is we should be able to prove that we treat people fairly, openly, recognizing their rights, their right to have control over their own identity, their right to have control of their own data. Keep in mind that the data that we collect about the users are the data belonging to the users, not to our system. We are just processing the data for their behalf. We want to provide the service, and we need their data for providing this service. We are not the owners of the data. the owner of the data is the end user, the user that's providing the data. So we need to make sure that we follow all the practices, the good practices, the technologies, the organizational measures in order to make our users trust us and provide the data. Okay. It's also about removing unnecessary barriers to trade and cooperation. Data protection is essential to innovation. The good practice in data protection is vital to ensure public trust, engaging people, and of course, be able to support, to create these mechanisms in order to help public and private sector provide innovative solutions and services to us, but always keep in mind that this engagement should be trustworthy. So, long story short, we need this regulation because we saw that until 2016, where this regulation started to be designed, researchers were talking about privacy, developers were talking about security and privacy, but it was not clear how to create this robust relationship among the clients and the providers. It was not clear how the public and private sector was addressing privacy issues, if they were addressing them. Okay, in what way? We had huge misunderstandings between security and privacy. I think we have them still. The pitfall, in my perception, is that many people, and especially the market, considers these directives as obstacles to them. While for me, and I think for people that are dealing with issues like that, these are good practices that, if we apply them in the right way, can be valuable tools to create this trustworthiness between the two parties. So let's start with here is the GDPR related definitions as they are described in the Article 4 of the General Data Protection Regulation. I'm not going to go through all this, but I have the most important ones that we need to examine. First of all, let's start with the concept of personal data. So if I ask all of you, can you define what personal data is? Most people will just come up with a profound answer that personal data is the name, the surname, the home address, the email address, the telephone. Okay. In general, personal data are any type of information, not just the profound ones, any type of information that is related to data of a person, either directly or indirectly, that can identify this person either directly or indirectly. Now, this is a very important detail. When we're talking about ability to identify someone, we're talking about all the concept. We're talking about all this data, let's say, surrounding us, that in one way or another can lead to the identification of the person. This means that I may have a data set of personal data that can easily identify who the user is, or I can have a data set which are not directly data that directly are linked to an identity, but if these data are presented in a specific context or they are linked with another data set, may lead to the identification of the data subject, as we call it. So under the GDPR perspective, and I think it's not the GDPR perspective, it's the actual, it's the real perspective, let's say, that if I have a data set in front of me that directly or indirectly can lead me to an identification of a natural person, then for me, these data are personal data. And why I make this so clear is because if you hold in your hands a data set that contains potential data that can link a personal a data subject, then by default, these data fall under the GDPR, which means that you have to respect them like they are actual personal data. Okay? Now, The second misunderstanding is that people consider that if a data set does not contain any direct identifiable information, then this data can be characterized as an anonymous data set, which is a huge mistake, because by characterizing a data set as an anonymous data set, the first, let's say, requirement that has to fulfill is that an anonymized data set by any means cannot be linked or processed in a way that will lead us to the identification of a natural person, of a data subject. So for us to be 100% sure that we are holding an anonymized data set, we need to be sure that these data are not directly identify a person, or even if they are linked with other data sets, again cannot lead us to the identification of one natural person. So it is very important not only to understand the notion of personal data, but in order to understand when we're talking about an anonymized data set, what does actually mean? In many circumstances, we had cases where stakeholders revealed, created open data from data sets that they thought they considered that they are anonymized, but at the end of the day, they were not. So this, of course, created a lot of flaws in the whole process and for the stakeholders themselves. Personal data, and this is the second part that I wanted to talk about. Personal data that has been de-identified, encrypted, or pseudo-anonymized, but can be used to re-identify a person are not anonymous data. Personal data that has been rendered anonymous in such a way that the individual is not or no longer identifiable is no longer considered personal data. So if we manage to create a data set that the individual, the data subject, is not or no longer identifiable, then we are able to talk about anonymized data. And if we have an anonymous data set in front of us, if we manage to create a truly anonymized data set, then this data set is not under the GDPR requirements. Because it does not contain any personal data. So let's try to remember these two parts and be sure that if we're participating in a project or if we have an essay, an exercise, that we have data sets that we're using and we want these data sets to be open. In order for these data sets to be open, they should be truly anonymized. And if they are truly anonymized, it means that they don't fall under the GDPR legislation anymore. Now, of course, we have also the special categories of data. Why we have these special categories of data, as you see in the slide here, for example, racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union memberships, etc., all these data are considered special categories of data. The special categories of data are distinguished because they have this more, let's say, privacy severity and impact on the person that the data belongs to, and the GDPR demands, and I think I will say GDPR demands, but I think our logic demands that even our data, if we're providing them, if these types of data are provided to a third party, we want to be extra safe. We want to be sure that more technical measures are there for safeguarding these types of data because they are special categories of data, because they are sensitive data. And there are different requirements regarding the storage time, the way that we storage them, the retention, etc. So just to know that everything falls under the personal data umbrella, but there are some specific categories of data that are distinguished from the simple, let's say, personal data. And for this data, we need to treat them in a more, let's say, strict way, but in the good sense, strict way, in the sense that it's towards the protection of the users. Processing. Now, here I just want you to remember one thing. Many people believe that when we're talking about processing of data, we're talking about any action that we do on data related to actual processing them. So take them and create something new, a value. But for the General Data Protection Regulation, processing is all the steps that you do with the data, starting from the collection of the data. So even if I collect data from users without doing any other type of processing, just collecting them, this falls under the processing perspective, which means that I'm actually processing data. So don't just think about it as the time that I'm collecting the data because I will see what we're going to do with them. But so I'm safe. I can collect as much as I want, store them somewhere, and sometime I will decide what I'm going to do with them. No, that's wrong. If you are collecting data, you have already started the processing of the data. So you fall under the perspectives of the General Data Protection Regulation. You are actually need to start taking measures for the data that you have already collected. So security measures, privacy requirements are there from the day zero, from the day that you started thinking about the functionality of your system that is going to collect the data. There, you should also have the necessary measures about the security and the privacy. All these activities that you see with red are considered operations on personal data, thus processing of data. So here are some examples of processing of data: staff management, payroll administration, access to consultation of a contacts database containing personal data, sending promotional emails is, of course, processing of personal data, posting a photo, of course, is a personal data, not on social media, but just posting a photo on a website, storing IP addresses on your log files, again, it's collection, recording through CCTV, it's collection, and I think that you get the point. Personal data means any information that is related to, as we said, to the data subject. Now, this is a technical term for the individual for whom the data are belonging to. Now, we call all the data that we use for relating them to a data subject, we call them identifiers. An individual, so a natural person, is identified or identifiable if you can distinguish them from other individuals. Now, I would like to elaborate a little bit more on that. Of course, we understand that a name identifier is an identifier that is actually related to the natural person, so I can distinguish it. Of course, it can also be the most common means of identifying someone. But, and I want to keep that here, an identifier that is not actually directly related to a person, if I see it, as we said before, in a specific context, can also be an identifier for the person, while at the beginning it doesn't seem to be. For example, I may have an ID from a database, okay, that is a simple number, 1, 2, 5, 10, which if I see it doesn't make any sense. But if I manage to link this number, let's say, to another number of a student ID, let's say, that is on another database, I may reveal the combination of the identifiers, I may reveal to whom the data are belonging to. This combination of identifiers led me to identify the individual. So I consider both of these fields potential identifiers for the natural persons, which means that are personal data, that are considered in the set of personal data. So we cannot have an extended list of which is an identifier and which not. It depends on the context. If you read a little bit about anonymity and anonymization, you see that the game for anonymizing a dataset is exactly the opposite. If I manage to create a dataset that in any context cannot identify any data subject, then this is anonymous. I always say a story I would like to share with you here, a story that I say to my students about how the specific data set, one data set, can be identifiable and at the same time anonymous. So I would like to share this example to you. Maybe it will make it easier to understand this concept. Imagine that I tell to my students that I'm in a classroom and I'm teaching all this stuff about privacy and people are getting bored. So of course I know all my students, right? So I have the sheet with all my the names and last names and whoever is here. So it's not, I have an identifiable data set, let's say. So imagine this hypothetical scenario where all my students are holding the same bottle of water. And then as I turn back, I turn my back and I'm trying to see, to point something on my slides. One of the students throws a bottle to me. So I turn fast to them and the bottle has been replaced directly in front of the student that threw it away. Can I identify who threw the bottle? Not if I do the forensics and take the fingerprints out of the bottle, too much. But can I identify the student? The answer is no. But I'm having an identifiable set, right? But why this specific set remains identifiable related to the specific context? Because they share all the same characteristic. So I cannot distinguish one of them. So if I want to capture anonymity, the case is that I'm trying to create a set where I cannot distinguish data out of it. If I manage to distinguish, to gain knowledge for specific records from this data set, then I'm trying to go back towards identifying the set. So that is why I'm saying in this slide that any potential identifier actually identifies an individual depending on the context. And this is also why anonymity is based on this stuff. I'm trying to move a little bit forward. So what is a data controller? Any natural or legal person or public authority, agency, or other body which alone or jointly determines the purposes and means of the processing of personal data. Now, let's hold a little bit here as well. Someone is collecting data in order to do something. The data controller is, we call the entity that collects the data, and they have to identify to us, they have to tell us before the collection two things. The purpose, so why they want to collect the data, and the means for collecting the data and processing the data. This is about the transparency and the trustworthiness that we said before, okay? So anyone who collects the data needs to have at least one purpose. The scenario, and this is why I told you before, you cannot just collect data and see what you're going to do with them. I know many research institutions, I know many funded projects that collecting data in order to examine what they're going to do with that, which is actually in the wrong direction. When you start collecting personal data, the first thing that you have to answer is why I need this data, which is the purpose that I want to fulfill. And if these data are actually necessary for answering your purpose, then you're legit, you don't have an issue. But if the data are more than the ones that you need, then we are hitting in the data minimization principle, which says you collect the data, the least data required for conducting your purpose. This is why before the GDPR era, we had entities collecting data without any reason. And still there are plenty of websites collecting our data without any reason. They are serving a one purpose, but for this purpose, they need, I don't know, 3 types of data and they collect 5, 6, 10. Okay, and people are not aware of that. So they're providing more personal data than it's actually needed. So the controller is the person that decides how and why to collect and use this data. This is usually an organization, but also can be an individual, okay, a doctor or a lawyer, okay? Now, the processor is the actual, let's say, entity a legal entity, a public authority, or someone that can also process the data on behalf of the controller. Now, is it always necessary to have a processor and the controller as separate entities? No. There are, in most cases, there are entities where we have also the controller and the processor being the same entity. Okay? So, but of course, there are also controllers that can do the processing, or there are processors that process the data on the controller's behalf. Here I have an example about a controller and a processor. So, for example, let's say that an organization A provides payroll processing services to corporate customers. Organization A provides those services to its customers in accordance with its customers' instructions. Organization A also uses those data to perform benchmarking analysis so that it can sell further services, allowing customers to compare their payroll data to industry average. So, does organization A fall within the definition of a controller or a processor? And I don't want to make you any of these legal dilemmas. That's why I'm going a bit fast on that. Well, depending on the facts, as I said before, the same entity can be a controller in respect of some processing and can be a processor in respect of other contexts. So in this example, as I said, organization A is a processor in respect of the payroll processing services because it gets the data and processes them. So it provides directly data to the customers. And controller in respect of the benchmarking services, as it is the processing personal data to create benchmark for its own purposes. So it's also the data controller and the processor in the second case. Of course, we may have two controllers. Okay, so we may have two controllers that they can have an arrangement between them, so they can have an agreement between them in order to process data together for a specific purpose. We see that many times in projects. For example, I've been in an EU-funded project where we had 3 hospitals, and we wanted to have to conduct research on their data, of course. So we had a joint controllership agreement between the 3 hospitals that shared their data in a common database, and we managed to create a pool of data that we could process. So there was an agreement between the 3 data controllers and the processor did the processing on their behalf. Okay. Sorry, I had a pop-up from the Zoom saying that it is weird that I sound to another language that he used to listen to me. That's interesting. And I have also here an example like the one that I told you about the hospitals, which is about a joint controllership between an airline, a chain of hotels, and a travel agency. Okay, so there are 3 entities collecting data for their own purposes: the travel agency for booking the tickets, the airline for conducting the flights, the hotel for passengers to stay. So they have 3 different controllers, but they can join forces together to create a platform where someone can book the ticket, fly through the airline, and book the hotel and stay at the hotel. Here we're talking about 3 entities joining forces. These are called joint controllers. And also an example that I told you before. So this is actually, let's say the part about the basic terminology that you will see regularly when you deal about this concept of security and privacy. Now, a little bit about the protection principle and legal basis. Okay. Now, this will help you understand a little bit about the logic behind that. Because as I told you at the beginning of the lecture, it is very important not to understand the technical aspects only, not to understand the vocabulary, but to understand the concept. Okay, so there are specific data protection principles as it is described in the GDPR. Lawfulness, fairness, and transparency. Purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, and accountability. Now, I will go through, I have 1 slide each for each one of them, just to run them through, just to understand a little bit the idea behind these principles. Very, very brief. Lawfulness, fairness, and transparency. We told at the beginning that we want to create a framework where stakeholders, legal entities, public and private sector will create services for us, will collect the data, but this data should be respected. Users' privacy should be respected. So that's why the first principle is whatever you decide to do, always follow the regulation, be fair with treating the data, and be transparent to your users. Okay? That's the first principle. The second principle is talking about purpose limitation. I told you a little bit about the purpose before. The old story, before we got through this regulation, all this regulation was, let's collect data and see what we will do with them. No. As I told you before you start collecting the data, you need to define a purpose. And the purpose can be specific. It's not a purpose if you're putting a general statement in front saying, I want to collect data for my research. This is not a purpose. Okay. You need to be exact on what and explicit on what is your purpose. The purpose, of course, should be legit. I don't want to collect data to create a platform for fraud. Okay, so the purpose should be legit. The purpose should be explicit and well specified. Because the end user, us providing the data, should be able to understand why we provide this data, why we need to give the data. Okay, why we need to supply the data to the platform, to whoever asks for our data. So we need to establish a purpose. Why it is important? Because if this purpose is specific, explicit, and legit, we can go to the third principle, which is data minimization. We need to collect the minimum set of data that we need in order to fulfill our purpose. So if we go to our users and say, look, I want to collect your data, I want to collect your name, your last name, your date of birth, your social security number, because I'm going to provide this service for you. And this service can come from the legislation. We see if it comes from the legislation, what happens, or it's something that I want to sell as a product. So this is the purpose. And for this purpose, I need these 4 types of data. I don't need 6. I don't need 3. I need these specific types of data. And for me as a user, it should be clear how these data are going to be processed and why they are necessary. If I answer this simple question to my user, then I tick all the boxes. I am transparent on how I'm going to process from the first part. Okay, I establish a specific purpose and I say why I need these types of data. Now, if in these types of data you put your girlfriend's name or, I don't know, your mother's name, which is not required, then you are losing the data minimization principle. So stop. When we're deciding what data we're going to ask for, stop thinking in a sense that, as much data as possible, that's better for me. No, the least data possible to fulfill my purpose. That's the principle of data minimization. Accuracy, of course, when I collect the data, I need this data to be accurate, okay, always up to date. That's why we need to ensure that any inaccurate data are not considered, erased, or rectified without any delay. And of course, we need to provide the tools to the users to update the data. There is also another huge misunderstanding. We collect data about our users and we don't give them the ability to access their data. I know cases where users asked for their data from companies or the public sector and they couldn't provide it to them. They were finding excuses about not being able to provide it to them, which is a huge mistake. As I told you at the beginning, the data belong to us, belong to the people that are providing the data. The others are just entities that fulfilling a purpose and they process the data for a specific purpose. So it is very important to keep our data accurate, to have the security measures necessary to safeguard the integrity of the data, and of course to give always access to users to access the data and update the data also themselves or ask for erasing the data. Okay. Storage limitations. This has to do with the data retention policy that I will tell you at the end of the presentation. It's just one slide. What is the concept here? we don't need to store data that for a longer period than the period that is actually required for fulfilling our purpose. And you know what? You don't need to invent purposes just to store the data for more time. This is also not acceptable. You fulfilled your purpose, maybe for security reasons or for providing a service that needs to have a history of the data. You can keep part of the data, or you can anonymize the data if you want to keep them for statistical purposes. For example, the purpose that I want to keep the data for 10 years because I want to conduct statistical research on that is not true, because one purpose needs personal data for conducting that, but for the statistical analysis, let's say, you can just anonymize the data and keep the value of the data for your statistical analysis. So we always need to take the appropriate measures in favor of the user, not in favor of us processing the data. Now I'm coming from the other perspective. So always think about the least minimum period that you need the data to store. Integrity and confidentiality, of course, these two principles, security principles, that are always a principle also for privacy. The data should be processed in a manner that ensures appropriate security of the personal data, including protection against unauthorized or unlawful processing and against accidental loss, distraction, or damage. Using appropriate technical, and there should be and/or organizational measures. What does it mean? It means that I need to take all the necessary safeguards, all the necessary security and privacy requirements in order to fulfill that my data that I collected are safe and are not vulnerable to this type of threats. Okay, because I am accountable of this data, for this data. If the data leakage occurs, then I'm accountable. Okay, that's why you see all these huge fines in big companies. And here comes the accountability part, which I just said. Okay. How I'm taking the let's say I need to have a legal basis to process the data. I cannot just collect the data and process them. So the user somehow needs to agree on this processing. Okay. So there are various ways of discussing that. Sorry. You know the first one, the consent. So if there is no legal basis, I mean, there is no legislation telling me to do it, then of course, consent is the only way. Consent meaning that I have a form where I'm talking to the users and say, look, this is the purpose, this is what I'm going to do, this is what I want to collect, this is how long I'm going to store the data, etc., etc., etc. Do you agree? Yes or no? But of course, there are cases, for example, the legal obligation, or we're under contract. Okay. Now, if we have a binding contract, then in order to do my work, I need to get the data. There is legal obligation. I cannot decline to the tax authorities to provide my data because it's under legislation that I need to provide my financial and personal data in order to do the tax forms. Okay. If there is vital interest, health usually, or if it's a public interest that a research will be conducted for example, for improving the life of citizens. But in our cases, mostly we see the consent and the legal obligation. And these here are the rights of the data subject as they are mentioned in the GDPR, which is, of course, the users should always be able to be informed about the data, have access to their data, have the right of rectification, the right to erase their data, or the right to be forgotten, as we say, to restrict the processing if they want, to be able to transfer the data, the right to object on the processing, even if they have consented on that, and of course, they have the right to object to any automated decision-making process that they are involved. And I'm rushing it a bit, and let's go to the second part, which is the privacy by design. Why, for me, is the privacy by design very important? All these things that we discussed so far about the privacy terminology, the privacy principles of GDPR should somehow be bridged with the IT part, should somehow be translated, let's say, into the IT world. And what is the vehicle of doing that? From my perspective, it's the privacy by design principle. The privacy by design principle comes, as I told you a long time ago, it came through the GDPR under the Article 25 of GDPR, which talks about the data protection by design and by default. What does it mean? It means that it pops the question, how can the system analysts, you see we are coming now to the IT part, how can the system analysts and designers integrate in the software technical measures that are designed to implement data protection principles in order to meet the regulatory requirements and in parallel protect the rights of the data subjects? How can the system analysts and designers integrate in the software measures ensuring that by default, only personal data which are necessary for its specific purpose are processed? And how can they integrate measures ensuring that by default, personal data are not made accessible without the individual's intervention? So here we have three questions which are actually gives us the questions of how technically I can enforce all the things that I said before. And why is the means the privacy by design? Because the privacy by design discusses about, in the IT world, how to engineer the new systems in order to fulfill all these requirements. That's why the literature talks about privacy by design principles that are giving one step forward. If you see here the GDPR principles on the right-hand side and the 7 principles suggested from the literature on the left-hand side of the slide, you see that there is a matching. For example, the privacy by design talks about embedding privacy into the design of the system. So you don't build the system and at the end, you try to find out which is the best security mechanism to adopt in order to safeguard the system. No, you need to identify, along with the functional requirements of the system, the security and privacy related requirements. How I'm going to think about privacy requirements? You're talking about privacy design. You're talking about privacy measures. There are some standards that can help us doing this step. For example, it's the privacy by design standard from ISO, the 31700, which talks about, has 2 scopes. We have the 31700-1 and -2. The one is about privacy by design for consumers, goods and services, and the other one is the high-level requirements, and the other one is the use cases. And these are the scopes of the document. In long story short, these 2 documents, providing you know the ISO standards, they are a little bit more generic to cover more cases, but they give us a roadmap on how to address privacy by design principles in a real system, in a real IT system. The Institute of Operational Privacy in the US have also issued another standard. It's talking about the IOPD, the design process standard, which talks about privacy governance and risk analysis. And I'm going to stick a bit about the risk analysis, because if you see here the steps that are proposed by the Institute of Operational Privacy by Design, you see that in order to take the right decisions, it makes you conduct a risk analysis. Now, I will put an asterisk here. Risk analysis is also present in the GDPR. Why? Because one of the tools to understand which are your risks related to privacy is called Data Protection Impact Assessment, the DPIA. The DPIA is actually a risk analysis tool which is focused on the principles of the GDPR. So it is very important to understand here this, let's say, 2 worlds coming together. The security risk analysis and the privacy risk analysis are actually together here, because we were talking about privacy requirements and security requirements, but when we're talking about implementing these, actually we end up selecting security measures. And privacy enhancing technologies are again security measures. So how you end up in these technologies is a matter of a risk analysis, which is concentrated in one sense to the security aspects, in the other sense to the privacy aspects and all the principles that we said before. All these are ending up into privacy requirements, because if I want to fulfill this, if I want to satisfy this, I need to have tangible requirements. So which are requirements? What are the privacy requirements? The privacy requirements are statements that are reflecting all these principles that we said before. Usually they are derived from user needs, but also from legislation, but also from the data rules that every country has, the legislation that every country has, but also they are the product from the requirements that are coming from all this risk analysis that we said before. The privacy requirements are statements. Of course, if I get a system to analyze and you get a system to analyze, we may end up phrasing differently the requirements that we have to fulfill. But at the end of the day, we don't care about how we're going to phrase the requirement. We care that we collect all the necessary security and privacy requirements that we need to fulfill in order to comply with the general data protection regulation, but also actually comply with the principles that we need to respect for safeguarding users' privacy. In the literature, you will see that there are a number of privacy requirements, but in order to have this, let's say, primary list of concepts that are related to privacy, for example, as we have in security, confidentiality, integrity, availability, we have some keywords, we have some basic principles, and from these principles, we derive specific security requirements. The same applies to privacy. We have a set of specific privacy concepts derived from the literature that can drive us into generating more specific privacy requirements. So we have the anonymity, we have the pseudonymity, we have the unlinkability, not be able to connect two parts together, the undetectability, not be able to detect that two parts are communicating, unobservability, which is the sum of undetectability and anonymity, and personal data protection, which has to do with all the legal aspects, let's say, all the legal requirements, let's say. If we take into consideration this list of generic privacy requirements, this is, let's not say requirements, let's say concepts, okay, let's say generic privacy concepts. These concepts can make an analyst think, generate, derive more specific privacy requirements, and also can drive the risk analysis that we will conduct. You see here a nice figure of the security by design. The security by design is exactly the same as the privacy by design. The security by design talks about identifying security requirements. And these security requirements, again, are coming from user needs, are coming from legal legislation, are coming from the functional requirements that we want to address. These functional requirements generate non-functional requirements, generate security requirements. Okay, but what is important here to understand is that the security by design, you see it in circles, is in all aspects, in all steps of development. So when I'm doing my risk analysis, I'm thinking about security by design because I'm in the case of initialization of the project and analysis. And when I move into the design of the system, again, I'm conducting a security by design approach focused on the design of the product and then on the implementation. So the security by design principle is not about this theoretical aspect that we begin to see at the beginning of the stage before we start implementing. The security by design drives all the circle of software development until the selection of the implementation and the incorporation of the implementation techniques. And if we see security by design and privacy by design under one umbrella, we see that, of course, they are collaborating, okay? And, of course, privacy by design, the privacy by design identification of privacy requirements, let's say, of course, speaks with the security because at the end of the day, as I told you before, they are going to select common implementation techniques. They're going to select common measures in order to fulfill all these requirements. Here I have just an output of a paper that we have done back in 2013 when we were discussing about the cloud computing elements and if they are how we can safeguard, okay, let's say the cloud computing environment back then. This was a work conducted with one of my students back then, and if you see on the last column where we say security and privacy principles here, you see that we have managed to to bring together all these aspects that I told you before about security and privacy with the threat landscape here and the critical areas of cloud computing here, and see how many concerns we have for every threat. And here we're talking only about cloud computing. We're not talking about today's world where cloud computing is just part of this whole process with AI, with big data, with third-party platforms, with IoT devices, all interconnected. So it is very important to understand that. And in order to understand that, this is a privacy by design approach in order to identify all these concepts. And this is system agnostic, okay? It's in general about the platforms that we use in cloud computing. And of course, we have the era of AI, where in the era of AI, we try to educate, to create models, to train models, to have sufficient decisions, to make decisions as close to being real as possible, okay? But what do we need for training the algorithms? Of course, data. That's why we see now this huge hunting of getting all the data, because we have the AI, which is now with LLMs, everyone is using AI. I think it's a bit complex. It's a bit confusing that the actual AI is not the LLMs. The actual AI is something much bigger. But in any case, we need data in order to be able to conduct all this AI analysis. And if you see the circle of an AI system, you see everywhere data. We need data to collect because we want to train out, to process them and create this feature engineering, which features are valuable for our models in order to create the model, evaluate the model, optimize the model, and start creating output. And this is a circle that never ends. But the difference with AI in respect to the traditional systems is that the knowledge of this data is not stuck here in the database. The knowledge that follows the data follows all these steps. So even if I don't manage to get the data set, but I manage to get the knowledge out of the model, then again, may have privacy implications. So here things are much more important. Here we need more the privacy by design aspects, because we need to think not in one stage, not only in the place that we store the data or we collect the data, but we need to capture where the traces of the personal data are in an AI system, and how we need to protect not only traditional assets that we used to protect, but to protect also the whole life cycle. The AI Act that came in the forefront just in August, it was voted. It says that if you want to deploy a system that uses AI in Europe, you need to have a conformity assessment if that system belongs to the high risk level. And imagine what? The LLMs are in the limited risk level, because the only thing that we care about in the LLMs is the transparency of the algorithms, how they suggest us what they suggest. If we solve this issue, we are okay. But if we're talking about systems, AI systems that collect personal data for conducting, let's say, for employment or for education or for public services, this is much more important. So that's why for these types of data, for these types of system, the EU says, I need a conformity assessment, and I need you to think about cybersecurity here as well. And the EU says that it's not accepted to have, just to put some water, it is not accepted to have systems on AI. It's not accepted to have AI systems falling to these categories. So for social scoring, mass surveillance, manipulation of behavior, these are forbidden in EU based on the AI Act, of course. So you see that in order to be able to make a conformity assessment here, you understand that you need to prove which are the requirements that you are going to fulfill, why you selected these requirements, how this complies with the actual legislation. In order to have a product, it doesn't matter where you are in Europe. Okay, so keep that in mind as well. Okay, here I have an example about a real scenario where we live in an interconnected world where we have various assets over various networks unreliable, sorry, and untrustworthy. So it is very, very important to start discussing about how to safeguard not that just the car, to safeguard the whole system, which has cloud platform, which relies on a third-party provider for telecommunications, which has a smart card that always collects and broadcasts data. And we use AI in that system. So imagine how complex that system is. So how much more the analysis is important before we proceed to any type of implementation. And last but not least, I have here this diagram that I found for you from a paper a few days ago. It shows a bit the difference between the in the LLMs now, in the large language models world, the difference about privacy between the traditional models, about the deep learning model, and the LLM world. And you see here that one major difference. We're conducting some research now with a PhD student of mine about how prompts, I think it's a very popular topic, many people are dealing with that, how prompts in LLMs can lead to privacy violation and identify users. And the results are amazing. And why is that? Because it's not only about how we prompt an LLM, is that all the database and the knowledge that the LLMs gets, it's not only about the training of the LLM, it's trained because all this data that we put as prompts and adopt as solutions, as answers, are going back to the LLM. And this knowledge stays in the LLM and maybe affects the new answers that the LLM will give. So imagine that even the prompts that we provide, which are not considered the data, personal data, let's say, if it's not actual personal data involved in the statement, sometimes they are also, are fed back to the LLM. So it's not only about our use. Other people may take advantage of that, or people, they start finding things about us. So this retrofit here, this feedback is very, very important in LLMs. There are plenty of security and privacy issues there as well. And I like the part that here there's not only technical aspects that we need to concern about, but there are also strong ethical, social aspects that we also need to consider. Finally, just one slide about data retention. I think that I made myself clear when we're talking about the data storage. In general, as a tip, I would like to close that when developing an information system or establishing an activity that will provide data processing, always check, always examine the data retention policy that you are going to have. And it's not an option, the answer is not, this is the time that I foresee that I will need the data, or this is the time that I believe I will need the data. When you decide the data retention policy of your system or a process, you should always have predefined specific criteria on how you made this selection. Why? Because as we said, storage is one of the key processing activities on personal data. So it is very, very important to have two things in mind. The least time to store the data, and for the time that you selected to store them, have specific criteria why you pick up this time, this period, and have a clear and transparent process to delete the data, transparent to the user as well, to be able to prove to your user that the data are actually deleted and not transferred to other servers, and to delete the data when the data retention period is over. So things that I think that we will demand as users, that if I may close with that statement, do what in your systems, when you design a system or you design a process that collects personal data, take the decisions that you would like to see if you were a user using your system or another system. Demand from yourself as a programmer, as a designer, to follow up decisions that you would expect someone, a third party, to do with your own data. I think if you have that concept in your mind, always you will be on the safe side. Thank you very much for listening to me.